Jeff Bezos supported Ripple XRP and will speak at trial today. U.S. Representative Brad Sherman recently advised the Securities and Exchange Commission, SEC, to go after crypto exchanges that supported Ripple's XRP token. However, in a recent interaction with Fox Business journalist Eleanor Tourette, Sherman made another claim against the token. Welcome to the Finance Up channel. If you liked this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end, to like and subscribe. The cryptocurrency community is discussing the SEC's victory over the Library crypto company. In May 2021, the SEC sued Library for offering unregistered securities to American investors. The Securities and Exchange Commission filed a lawsuit against Library, a digital content distribution company and a trading platform for it, just a few months after it filed a similar lawsuit against Ripple. Many crypto and legal analysts predict that the outcome of the Library case will play a key role in the Ripple lawsuit. Attorney John Deaton, founder of Crypto Law, was among the legal analysts reacting to the SEC's victory over Library. In a tweet today, Deaton noted that the Securities and Exchange Commission will refer to the Library verdict in its upcoming brief responses to Ripple's motion for a summary judgment. He said Ripple would also likely mention the case in the company's own response to the Securities and Exchange Commission's motion for a simplified procedure. He also expects the SEC to take advantage of its victory over Library in the Ripple lawsuit. Deaton also pointed out the difference between these cases. This decision is in the First District. The Ripple XRP case is in the Second Circuit and has a different precedent, as does the Upton case, he added. I didn't have time to read it, but I'm sure at SecGov will quote it in a short answer in a couple of weeks, and at Ripple will distinguish it by the facts. This decision is in the First District. The Ripple XRP case is in the Second Circuit and has a different precedent, as does the Upton case. In a separate tweet, Deaton also said that the SEC won an impeccable victory over Library, since the court did not distinguish between the sale of the token. He added that the SEC and its chairman Gary Gensler will use this case as an example against crypto projects in the future. Unfortunately, this is a complete victory for the SEC, as the judge does not distinguish between secondary market sales independent of or future sales compared to past sales. Get ready with it, Gary Gensler? ? And the SEC will use this case as an example to move forward against crypto. Lawyer Jeremy Hogan, a partner at Hogan Hogan, also comments on the development. Lawyer Hogan also expects the SEC to take advantage of its victory over Library in the Ripple lawsuit. Library fought a good fight, but lost in summary proceedings. The judge pretty much hung his hat on the fact that the tokens were practically not used during the sale. I expect this case to get into the final report of the Securities and Exchange Commission on the Ripple case. The court added that the main problem with LBRY's fair notification argument is that it offers nothing other than its frank statement that this is the first time the SEC has tried to apply a registration requirement against an issuer of digital tokens that did not conduct an ICO. The court further stated that Library does not point to any specific SEC statement that companies should comply with the registration requirement only if they conduct an ICO. The court concluded, the SEC did not base its enforcement actions here on a new interpretation of the rule, which under its terms does not explicitly prohibit the relevant behavior. Instead, the SEC based its claim on the direct application of the respected Supreme Court precedent, which has been applied by hundreds of federal courts across the country for more than 70 years. While this may be the first time it has been used against a digital token issuer that did not conduct an ICO, Library cannot claim that it did not receive fair notice that its conduct was illegal. The SEC's approach to regulation through enforcement is not popular. But despite the unpopularity, until the laws are changed or the SEC suggests a more viable way forward, issuing tokens according to current models will remain a challenging task. The Securities and Exchange Commission is stepping up its enforcement efforts. This decision is likely to contribute to the development of this trend. If you are issuing or have issued tokens, you need to make sure that you have protected your legal grounds. Increasingly, the end of March 2023 sounds like a likely end date for the ongoing litigation between Ripple and the U.S. Securities and Exchange Commission, SEC. To the delight of conspiracy enthusiasts, at the same time, the launch of ISO 20022 was postponed from November 2022 to March 2023. James K. Phelan, sharing an updated schedule of events in the Ripple trial, stated that, despite a slight shift in events, he continues to adhere to his forecast that the Torres district judge will decide both on the petitions of experts and on the petitions for a simplified procedure at the same time, no later than March 31, 2023. I am sticking to my prediction that District Judge Torres will decide both the expert motives and the summary judgment motives at the same time, on or before March 31, 2023. Jeremy Hogan, an American lawyer and partner of Hogan, who is following the case, supports James K. Phelan's prediction about when Judge Torres may decide on expert petitions, as well as on a summary judgment. As he tweeted, and here it is. March 31, 2023. And there you have it. March 31, 2023. This means that the case is likely to be resolved within the next 4 months, which is a very optimistic forecast. Ripple's CEO Brad Garlinghouse told the DC FinTech Week conference that the SEC's lawsuit against Ripple will be resolved in the first half of 2023. According to Garlinghouse, there is a chance that the lawsuit can be settled in the next 3 to 4 months. However, he does not rule out that it may take longer. Garlinghouse added that Ripple may consider settling with the SEC, but stressed that XRP must first be recognized as a non-valuable paper. In September, the SEC and Ripple filed motions for summary judgment, asking District Judge Annalisa Torres to rule based on the arguments presented in the accompanying documents. Subsequently, both Ripple and the SEC filed their objections to each other's motion for a summary judgment. It was expected that responses to the motions for summary judgment would be received by November 15, in accordance with an earlier schedule of events in the case, but they were postponed to November 30, when it is expected that all briefings will be completed and Judge Torres will make a final decision. One interesting point noted by members of the XRP community is that now the launch of ISO 20022 coincides with the end of the trial, after Swift announced that it was postponing the transition to ISO 20022 from November 2022 to March 2023. The decision to postpone Swift was made at the request of the international financial community in connection with the change of the date of migration of the Eurosystem to ISO 20022 in the field of cross-border payments and reporting, CBPR+. The first thing that comes to mind is Bitcoin, the leading cryptocurrency, and Musk's pet Dogecoin. Well, if everything is more or less clear with Doge, since it is already accepted as payment for some mask products, then you can only guess about everything else. Well, known crypto investor Anthony Pompiliano claims that Bitcoin is the only means of payment that can process instant global microtransactions on a scale. Many Twitter users objected to this statement and said that the Bitcoin network can only process 7 transactions per second. If Elon Musk really wants to turn Twitter into a payment app, then Bitcoin is the only payment network that can handle instant global microtransactions at scale. Twitter tipping already allows users to send US dollars or BTC via the Bitcoin network, which is a natural extension. A well-known lawyer in the XRP community, John E. Deaton, called Pompiliano's opinion clearly erroneous, adding that Twitter used its own Ripple token, XRP, for micropayments many years before BTC. In order not to be called an XRP fan, Deaton stated that he has more Bitcoin than XRP, and he was only trying to lay out the actual arguments regarding Ripple. I'm not sure why people say things that are clearly not true. The current price of XRP for today you can see yourself on the screens, and the trading volume for 24 hours is $1,294,436,065 US. We are updating our XRP price in US dollars in real time. XRP has dropped 4.08% in the last 24 hours. Do you think XRP will be able to win the court and restore its former price? Write the answers in the comments. That's it for today. Thank you for watching this video to the end. If you liked it, then don't forget to like it and subscribe to the channel.